Great. All right. So we set the streaming up. Great news here. So we're going to join on Instagram as well. Perfect. Hi, everyone. This is Natalia from Mackenzie Law Group, and I'm here today to present on the First Friday event that we have every first Friday of each month. We tell you about immigration news, immigration updates regarding business immigration, family immigration, and all other kinds of immigration news we encountered this past month. So, happy first day of March. And I'm excited to present and tell you about the most recent immigration news to keep you updated and informed. We're starting a little bit later today because we had some unexpected technical difficulties. So sorry if you joined us at 12 p.m., but the webinar did not happen. Well, I'm here today and right now to tell you about all the news, and I'm just going to wait for another minute to allow people to join this live session with Mackenzie Law Group. Happy Friday to everyone who joined. I hope you have some great plans for this weekend. We have really good weather podcast for this coming weekend in Chicago, so we're very much excited about it. All right, let's start. The very first news that I'd like to cover, and that's kind of, what pretty much everyone talks about who has anything to do with immigration. As you probably know, the US government has announced fee increase for immigration petitions and applications that people file with the USCIS. And I'm going to give you an example or a couple of examples of how the fees went up. The new fee schedule will be in effect starting April 1st of 2024. So if you have this plan to file a case with the USCIS, my advice is to get it done in March before April 1st of 2024. Then, most of the fees go up on April 1st of 2024. And sometimes it's quite a significant increase. So let's go to an example that I have here. So if you are planning to file a family-based adjustment of status in the United States, keep in mind that in March, your fees, government fees, will be around $1,800. And that amount would cover Form I-130 petition that a petitioner files for the foreign national citizen, I-485 application for a green card. The fee would also covers, as of now, Form I-765, which is an application for an employment authorization, and Form I-131, which can be an application for either an advance parole document to allow for a national to travel outside of the United States and then get back to the US in the same status. Or sometimes we file for a refugee travel document as part of the adjustment of status application process if we deal with refugees or asylees in the United States who file for green cards. So currently, you pay $535 for the petition, $1,225 for the application for a green card, and you don't have to pay for the advance parole document or employment authorization document. Well, this is going to change starting April 1st of 2024. The overall adjustment of status one-stop process fees will go up from roughly $1,800, which we have right now, to $3,005 starting April 1st of 2024. That's quite a significant increase, and it is explained by the fact that the USCIS will not allow to file forms I-765 and I-131 free of charge if you file them with the application for green card, but it will in fact charge an additional amount for each application. In addition to that, the USCIS will charge more for Form I-130 and for Form I-485. So that's how the fee goes up by roughly $1,200. And especially if you are a family and you have several people in your family that will be filing for green cards, then my advice is to, if you would like to save on the filing fees, is to prepare and file before April 1st. And don't wait until the last week, because what the USCIS has done in the past is they would receive the petitions and applications right before the fee increase, and they would send the applications and petitions back to the filers saying that we cannot accept your applications or petitions because the filing fee amount is incorrect. You have to refile. So if you plan to file before April 1st, I would recommend to file 2 weeks in advance and allow some time for to get this receipt notice, to make sure your case was received by the USCIS before April 1st, because if it's received after April 1st, then or on April 1st, then different filing fees will have to be paid. And then also think about FedEx, UPS, and USPS having way more envelopes going to the USCIS during this specific period of time, because there will be many petitioners and applicants trying to file their cases before the fee increase. So just keep this in mind. A couple of more examples. Form I-751. So the current fee is $680, and this will go up to $750. The N400 fee is currently at $640. It will increase to $710, but the biometrics fee will not be paid after April 1st, and it has to be paid before April 1st. So keep that in mind. Another fee increase is associated with this specific form that we file for the premium processing, request for premium processing service with the USCIS. This is the form that we very often file with forms I-129, which is the petition, employment-based petition. So right now, the fee for this specific request for premium processing is $2,500. Starting February 26th of 2024, this fee will go up to $2,805, so it will be $2,805. So it's roughly $300 increase on that. The fee really for this specific request depends on what kind of petition or application you're filing with the USCIS. So if you are, let's say, are filing Form I-539, then the filing fee for the request for premium processing will go up from $1,750 to $1,965. If you're filing this request with Form I-765, then keep in mind that the fee will go from $1,500 to $1,685. Just a reminder that Form I-539 is this application to exchange status or to change status or to extend status in the United States. And the application Form I-765 is an application for an employment authorization. As of last year, the USCIS actually is allowing filing a request for premium processing on forms I-765. Another useful news to actually pay attention to is that starting April 26th of 2024, the USCIS will only accept the February 26th of 2024 edition of Form I-907, which is a request for premium processing service. So any other editions that existed before April 26th of 2024 will not be accepted. So if you have some kind of case that you would like to file with this request for premium processing, and you prepare this form in advance, then file after or on April 26th of 2024. Just make sure that the edition of the form is correct, because wrong editions of the form mean denials of the cases, and we don't want any cases to be denied. Moving on to the Uniting for Ukraine program. That's a humanitarian parole program that was introduced by the Department of Homeland Security in 2022. A lot of people, citizens of Ukraine, came to the United States based on this parole program and still remain in the United States. So those people have their parole authorizations expiring either in 2025 if they filed in 2024, if they filed in 2022, and in 2025 if they filed in 2023. So depending on the date when a person filed for this parole authorization, the expiration date may be different. Re-parole process was authorized by the Department of Homeland Security for those who came on Uniting for Ukraine parole on or after February 11th of 2022. This is great news for those Ukrainians who are in the United States and have their parole expiring. Go ahead and file Form I-131 with the USCIS, and be mindful that you also need to include at least, some amount of evidence of your entry into the United States on or after February 11th of 2022. That can be Form I-94 that you can obtain online on the CBP website. You also will need to establish that humanitarian concerns and this extreme humanitarian situation in your country continues, and that you warrant a favorable exercise of discretion from the USCIS to have your parole extended for up to 2 years. Once the parole is extended, you can file for work authorization that will be valid for the amount of time authorized under this parole extension application approval. This whole re-parole process is relatively new process for those Ukrainians who maybe we're not familiar with other parole programs that the USCIS has in place, but overall, re-parole program is not new for the USCIS. The USCIS has authorized re-parole for example, Afghan nationals in 2023. And here at McKinsey, we filed a re-parole application in December, and it was approved within 3 weeks for an Afghan national. So we do have, this is our most recent re-parole case. So we do have experience helping people with re-parole applications and documenting the case properly, so it could be granted without a request for evidence or any delays on the case. Obviously, each situation is different, and you should always keep that in mind because the processing times can differ as well. A deferred enforcement departure and an ability to apply for an employment authorization is also here now for certain eligible Palestinians who are in the United States. This deferred enforcement departure is a program that is authorized by the Department of Homeland Security for citizens of certain countries who are currently in the United States. So this program by itself does not lead to any permanent status in the United States, but it would allow for the protection from deportation from the United States. It allows for an employment authorization, in this case, for 18 months for eligible Palestinians. We don't yet have the specific instructions from the USCIS on how to actually proceed with this request, but the instructions will be posted on the USCIS's website as soon as they become available to them. And it is important that you keep an eye on the developments in terms of this deferred enforcement departure, because at any time in the nearest future, the USCIS may publish specific updates regarding this program. Another humanitarian program that existed for Syrian nationals has been extended by the Department of Homeland Security. So the DHS extends and redesignates Syria for temporary protected status. Temporary protected status is a protection from deportation. It's an actual immigration status as opposed to parole, for example. So TPS is authorized by the Department of Homeland Security if there is, for example, a civil war, a war in a country, or a humanitarian emergency. So for Syria, TPS was introduced for 18 months beginning April 1st of 2024, and it will be in effect until September 30th of 2025. An initial application can be filed with the USCIS as well as an extension. So those who have TPS right now can re-register within 60-day period specifically indicated on the website. Those who don't have TPS as of now may be able to apply for TPS and get it granted, apply for an employment authorization or a travel document along with the TPS application. So keep in mind that you just need to prove your continuous residence in the United States starting January 25th of 2024. And you need to prove your physical presence in the United States since April 1st of 2024. Those are standard requirements. Those are not only requirements for TPS. There are obviously inadmissibility questions on that application just to determine if a person can qualify for TPS or if a person needs a certain kind of a waiver application filed along with the TPS application for it to be granted in the future. Once again, this was TPS for Syria. And if you're a Syrian national, the USCIS has all the instructions published on its website already. So go ahead and check them out. And if you need our help, we have experience filing TPS applications with the USCIS. So much for the humanitarian programs. As we know, the USCIS handles family applications, employment petitions, and also humanitarian applications and programs. If we talk about business immigration, employment immigration, then big news there is, of course, the H-1B lottery. So the H-1B registration period for fiscal year 2025 will open on March 6th, so in 5 days, at noon Eastern time, and it will run until noon Eastern time on Friday, March 22nd of 2024. This time period is extremely important because if you want to participate in the lottery, which is the very first step in the whole H-1B process, and if the this cap applies to you, then keep in mind that you can enter the lottery only during this process. And as the USCIS has indicated before, and as we also discussed this and spoke about this during our H-1B webinar earlier this month, the US will implement a new beneficiary-centered system, not the petitioner-centered system, to ensure that all beneficiaries have the same chances of selection. So this year, the whole H-1B system will be more fair to the beneficiaries. And if you were not selected previously, please go ahead and try this year. It may be different for you. Also, good news is that the USCIS has confirmed that the H-1B registration fee for this specific fiscal year 2025 will not increase to $215, and it will remain at $10. These are amazing news regarding the H-1B process. And if you are interested to apply for an H-1B, you're considering this employment immigration option or any other employment immigration options, please consult with an immigration attorney because this is a complex area of law, and a consultation with an immigration attorney may definitely be beneficial to you in this process. Next, we are moving to the news of January 2024 of January 24th of 2024. That's when the USCIS updated its policy guidance to provide that the USCIS, in its discretion, so it's discretionary, and under certain conditions may extend or change status, and at the time allow for it, and at the same time excuse a non-immigrant's failure to timely file this extension of stay or change of status request if the delay was due to extraordinary circumstances. And luckily for us, the USCIS actually outlines the extraordinary circumstances and the examples of the extraordinary circumstances. So it's saying that may include, for example, work slowdowns or stoppages involving the strike, lockout, or other labor dispute, an inability to obtain a certified labor condition application or temporary labor certification due to a lapse in government funding supporting those certifications. So keep this in mind. If this is your case, then this specific policy guidance may be extremely useful and can help you to actually get your application for a change of status or extension of status granted if you meet the requirements. So it's always good to know what the USCIS thinks in terms of adjudication of a certain petition or application. That's why policy guidelines, even though those are not the specific laws, those are extremely important in terms of immigration. We always keep a close eye on any changes in the policy. So these are the news that I wanted to cover today. I know a lot of people are interested, regarding what's going on at the U.S. southern border. The Congress is still deciding what is going to happen. So the Republicans and the Democrats are arguing over the border policy. A lot is happening this year with the upcoming elections as well. And as we know, the Republicans have certain plans in mind and the Democrats have certain plans in mind in terms of the southern border. But as of now, there are no major changes to the asylum process at the border. As of now, we don't have any additional policies newer policies or regulations in place that we would be able to cover as immigration news during the first Friday, but we follow the news that come from the US Congress. And if anything happens in regard to the southern border, we'll be among the first ones to talk about that. All right, let's get to the questions. Question number 1. My fiance filed Form I-129F, and he and I are now in the United States. We got married here in Texas. Can we still pursue I-129F petition? Unfortunately, no. And it's because you are not engaged anymore. You are actually now married. And there is a completely different process for the married couples. And it's not I-129F petition. So if you filed that petition in the past when you were engaged and now you are married, you need to withdraw this petition from the USCIS and let them know that you are no longer pursuing this petition. And since you're now married, the right process for you would be applying for an immigrant visa and filing Form I-130, then going through the NVC process and through the consular processing. If that so happens that you are in the United States, then the right process would be to either go back to your home country and complete the whole process, or depending on your circumstances and your status in the United States, an adjustment of status may be also possible within the United States. I see a question online, so I'm just going to read it here. Sister wants brothers in the US. Sister should file Form I-130 now, or is it better to file it through mother, as mother of kids will become a US citizen next year? What is your suggestion for Poland? This is a great question. So to answer this question, I would assume that the sister is a US citizen and wants to file for her brothers and for her and there is a US citizen mother who may also file for her children. All right, so the answer to this question really depends on whether we're talking about children or daughters and sons of US citizens, for example. If it's children, if it's someone under 21, then that child is an immediate relative of a US citizen, and then the visa is available right away. For immediate relatives, it's recommended that people just start the process as soon as possible if that's the goal, to get to the United States. And for immediate relatives, usually it takes I would say about 1.5 years from the very start and until the end to allow to have those people enter the United States on green cards. If we're talking about preference categories, so those are not children of US citizens, those are sons or daughters of US citizens, or those same people can be sisters or brothers of US citizens. So which process is better depends on the visa bulletin. And every month, the Department of State publishes a visa bulletin for a specific month. And the dates indicated in the visa bulletin change or may change significantly or insignificantly. So you always need to keep an eye on the visa bulletin. If you see that, looking at this visa bulletin, if you see the specific category for sisters and brothers, that takes about 14 years for them to come to the United States, then look at a different category, which is sons and daughters of US citizens. And if it says that it takes, if depending on the date, you determine that it takes 13 years, then obviously filing for sons and daughters may be more beneficial, than filing for sisters and brothers. But that may change depending on the visa bulletin. So my best advice would be to keep an eye on the visa bulletin. If you would like to kind of, see what happens in the future and have both options open to you, because we never know how the visa bulletin will look the next month until it's published. You may file for, as a US citizen sister, you may file for your brother, the I-130 petition, and a mother of a US citizen mother of a child over 21, so a son or daughter, may also file that petition. And the same person, who's located outside of the United States, may have two petitions pending with the USCIS. And then depending on the priority date on each petition and the category and the visa bulletin in place at a specific time, you will see which one kicks in first. So predicting which one kicks in first probably does not make sense, because the visa bulletin changes all the time. But to increase the chances, you may have two petitions pending at the same time. And then as time goes by, you will be able to see which one actually kicks in faster. And it's both of them will be preference category petitions. So it will take around, as of now, the visa bulletin is telling us it's around 14, 15 years. So it's a pretty long time wait for those specific petitions. One last question that I have here is, my case has been pending without an interview. I filed for an adjustment of status for more than 2 years. What can I do? People start thinking about litigation usually right away. I personally think about litigation as the last resort. So I would advise to push the case forward using other means first, and then think about federal litigation. What you can do, you can request congressional assistance in pushing this case forward at the USCIS. You can request the USCIS Ombudsman's office to help you with the case. Ombudsman's office is actually a great resource that we often use here at McKinsey, and it helps so many of our clients. And I just cannot emphasize enough how important it is to keep in mind that this specific kind of request may be available to you. Why I say maybe is because you need to take some additional steps before you actually get to the ombudsman's request, and a certain amount of time, should pass before you actually request the ombudsman's assistance. So if it's a reasonable amount of time of the application pending without an interview, the ombudsman's office will probably not be very helpful. If it's an unreasonable time, and it's like in this question, it's been 2 years, then obviously I would go ahead and ask both the congressional office and the ombudsman's office for help. Happy Friday again. I hope those answers to the questions were very helpful to you. We'll be here again in April. Every month we host first Fridays for our subscribers, and it will be a different attorney next month. This was Natalia Blauvelt, an immigration attorney with McKinsey. Have a nice weekend and happy Friday.